Good morning. You're Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson was previously in court, entered pleas of guilty in all three of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
I'd just like to address one thing Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think. And I'll ask my client to clear it up. Now, you're working for a home health care agency, is that correct? And
Answer yes or no, please.
And your client at the time had asked you to dispose of some personal banking checks, is that right?
Yes, and I took them. I misspoke. I meant to say I took the checks, and I knew that Adrian Hayward was going to cash them, so I'm just as guilty as him.
So, and she said in here that she's the one who took them.
Yeah.
So I'm okay with that.
Brought it up, and
Okay.
I had to clear up culpability.
I appreciate that. Yeah.
This admission carries important legal weight. Although another person allegedly cashed the checks, Johnson acknowledged that she took them with full knowledge of what would happen next. Under the law of parties, a person can be held criminally responsible if they knowingly and intentionally participate in a crime. The state does not have to prove that she personally cashed the checks to establish her liability. By putting this clarification on the record, the court removed any uncertainty about her role in the forgery scheme. The key issue is not who completed the final act, but whether Johnson knowingly took part in the fraudulent activity. Her own statement confirms that she understood the nature of the offense and willingly contributed to it. This record is significant because it strengthens the legal basis of the case and limits any future claim that her involvement was accidental, misunderstood, or minor. In the eyes of the law, intent combined with knowing participation is enough to establish responsibility.
They've never caught AJ.
No, I've been hearing that he's incarcerated, but I haven't.
Okay.
Thanks.
Any other issues?
No, Your Honor.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shelton, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss them, but I didn't have paperwork on probation.
Okay. What?
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the won't abandon and get some of the CPS rules. I didn't see that.
Well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and
We can go talk to Judge Shelton maybe, or no, this is fine.
No, I mean, that's as long as but she's going to have to give her probation officer documentation from CPS. So you can work that out with your probation officer.
The judge has directly connected Johnson's criminal probation to her Child Protective Services CPS requirements. This means her freedom is now tied to compliance in two separate systems at the same time, the criminal court and the family court. Any failure to meet the conditions set by CPS, even a technical or administrative issue, could be treated as a violation of her probation. This creates a layered level of supervision that significantly increases the pressure to comply. Johnson must now meet the expectations of both systems simultaneously, and any misstep in either one could have serious legal consequences. By linking these obligations together, the court has raised the stakes, making strict compliance essential to avoid further penalties or the risk of incarceration.
It's going to be no unsupervised unless, and then if
yes,
probation
okay.
gets that information and she's doing her safety plan and everything, then we're going to be okay with that here also. But they're going to kind of be the ones that dictate that process, not me.
Just kind of nebulous. A couple conversations with appointing counsel on that, and a couple conversations with the caseworker.
Okay, all right, so
Get
Ms.
this
Johnson.
done is what he told me, so.
Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity, because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right? Good luck to you, ma'am. Thank you, Mr.
Eduania Johnson entered the courtroom after already pleading guilty to 3 felony cases, 1 for forgery and 2 for injury to a child. Before sentencing, the judge reviewed the pre-sentence investigation report and confirmed that there were no significant disputes that would delay the process. Early in the hearing, Johnson clarified her role in the forgery case. She admitted that while working for a home health care agency, she took checks from a client, fully aware that another individual intended to cash them. Although that person was never apprehended, Johnson accepted responsibility for her involvement. This admission strengthened the legal foundation for holding her accountable under party liability principles. However, the criminal charges were only part of the situation. Johnson's children are currently in foster care, and Child Protective Services remains actively involved. The long-term plan is reunification, but only if she fully complies with all CPS requirements. Recognizing the overlap between the criminal case and the family situation, the judge made a critical decision. Johnson's probation would be directly tied to full compliance with her CPS plan. This includes parenting requirements, documentation, and strict limitations on contact with her children. She is prohibited from having any unsupervised contact with any child under the age of 18, including her own, unless CPS approves it and probation receives official verification. This condition effectively places her parental rights and her freedom on parallel tracks. The court then ordered deferred adjudication in all 3 cases. In cause number 24 DCCR 2151, proceedings were deferred for 6 years along with a $500 fine. In cause number 24 DCCR 2152, the court imposed 5 years of deferred adjudication and another $500 fine. In cause number 24 DCCR 2153, proceedings were deferred for 5 years with no fine. In each case, Johnson must comply with all terms and conditions of probation. Legally, deferred adjudication represents both an opportunity and a risk. It gives a defendant a chance to avoid a permanent felony conviction, but only through strict and consistent compliance. This case demonstrates how deferred adjudication can function as a bridge between accountability and rehabilitation. Now the question becomes, does tying criminal probation directly to CPS compliance increase accountability, or does it make success significantly more difficult? If you value clear, fact-based courtroom analysis like this, be sure to like, share your thoughts in the comments, and subscribe for more in-depth legal breakdowns.